The power of notice, fault, default, and enforcement in commerce. 1. The silent engine of law. Every commercial process, no matter how dramatic it looks in court, begins quietly, with notice. The system runs on silence. Whoever controls the silence, controls the outcome. The one who sends notice defines the issue, the one who fails to answer defines their consent. So what does that actually mean? It means power belongs to the party who speaks first and listens last. Notice is not an invitation, it's a declaration of awareness. It informs the world that a claim exists, giving the other party the chance to rebut it. If they fail to respond in honor, they move from party to participant, from authority to accessory. Footnote. In commercial law, notice establishes knowledge of a claim, failure to respond constitutes tacit consent, forming the foundation of contractual estoppel. 2. The sequence of remedy. There are 3 steps in every commercial enforcement: notice of claim, notice of fault, and notice of default. Each is a doorway, and each one closes if ignored. The notice of claim asserts a right. The notice of fault identifies the failure to respond or cure. The notice of default finalizes the silence and perfects the standing of the claimant. At that point, it's not a request, it's a record. So what does that actually mean? It means law doesn't punish people for wrongdoing, it punishes them for ignoring certified mail. Footnote. The triad of claim, fault, and default forms the procedural ladder of administrative enforcement, establishing finality through non-rebuttal. 3. Fault, the gentle warning. Fault is the moment of mercy. It gives the opposing party one last opportunity to cure the default before it becomes binding. It demonstrates good faith and preserves honor, qualities the commercial realm respects more than passion or protest. When fault is issued, time begins to count. Every day of silence becomes a confession of incapacity. The process doesn't rush, it waits, patiently and legally. So what does that actually mean? It means the law gives everyone a chance to speak, but only once. Footnote. Notice of fault functions as both due process and mercy, allowing the respondent a final opportunity to cure before judgment by default. 4. Default, the crown of remedy. Default is not punishment. It is the quiet coronation of order. When one fails to answer, they forfeit their voice, and with it, their right to contest. The claimant then moves from requester to enforcer. Once default is established, all that remains is the execution of record, the lawful right to collect, lien, or liquidate. Courts recognize this not as rebellion, but as administration. So what does that actually mean? It means silence, when properly recorded, becomes louder than argument. Footnote. Default finalizes claim enforcement by operation of law, granting the claimant superior right to remedy through uncontested record,